Hello everyone, this is Roshni Sri Abhirami, a legal intern with LEXIS and Company. Today I'll be dealing with a very particular topic and two cases in this particular topic. The topic being Trademarks Act and the cases being the Tefal's case and the Nestlé's case. So basically I'll start on with the Tefal's case. So what is the Tefal case? We all know that Tefal is a company that produces cooking pans and other cooking utensils, basically non-stick cooking utensils. So basically what happens is that in the Tefal case, the registration of a trademark in the United Kingdom is denied due to the lack of distinctiveness under Article 3 Clause 1 Subclause B of the Trademark Act of 1994 of the United Kingdom's laws. Okay, so basically the facts of the case being Tefal applies for registering its red mark. Okay, so basically it produces a pan and frying pans and it puts a red mark on the pan, in the middle of the pan, and it says that I want to register this particular trademark, but the trademark is being rejected by the registration office. So it files a suit and the matter is being held in the court. So basically what happens is that Tefal applied to register its unique red mark in the United Kingdom for its frying pans and other related goods. Okay, so basically the red mark, but the mark was rejected on the basis of section 3 clause 1 subclause B of the Trademarks Act of the United Kingdom, because it was devoid of the distinctive character and would not have enough trademark significance attributed to it. So basically we all know that even though there is a significant number of people who identify the red spot at Tefal's red mark, there are certain people who would think that red mark is as in red mark itself. So the court says that if you could convince us that the red mark on a pan should be registered for a trademark, it could be accepted, but just a red mark which is which doesn't have a distinctive character, which is very generic in nature, a red mark, a red dot, cannot be registered itself. So this is one explanation given by the court for not registering the red mark. So basically the court held that the confidence in question is not necessarily independent to use the sign, but for example a refinery of the red spot in the same way, such as a pan with a red spot. So if suppose Tefal had said that I want to register a pan with the red spot, then that particular red spot can be trademark. But in this case what Tefal did was it wanted to register their red spot itself. It said that I want the red spot to be trademarked in its name. So the court held that it cannot be registered under the Trademarks Act. The court also considered a particular case law, that is the Society des Products Nestlé SA versus Cadbury United Kingdom Limited of 2017. So it introduced the question of reliance as opposed to association. The court also convinced that the evidence demonstrated that the red spot alone would be seen as an indicator of a brand origin as opposed to Tefal. So this was held in the particular case of Tefal. The hearing officer also also submitted his grave concerns that the applicant's sign was a heat indicator rather than any random red spot. We all know that in physics and thermal physics, we all would have known that a red spot means a heating object. So when a particular thing is getting heated, even when you look at a geyser or something, if it's in the red light, it means that it is getting heated. So basically a red spot actually means that a heating of a particular thing. So the court held that the mark cannot be divorced from its technical functions. So the hearing officer held his opinion that Tefal's evidence has been carefully curated to seek his attention away from the mark's technical functions. So basically you cannot claim a trademark on this particular red spot because it's very generic and it can be used by anyone in order to indicate a heating object. So this is one among the cases that I wanted to explain. The next case being the Nestlé's case. The Nestlé's case is pretty interesting. So what happens is that we all know that Nestle has its own, monopoly in the market with all its four-finger shaped Kit Kat. Okay, so basically Kit Kat produced by Nestle is like a four-finger, four strips. We all know that. So basically, this case is about that. In 2010, what happens is that Nestle applied to register the four-finger shape of the Kit Kat chocolate bar that it produces. So basically, but Cadbury, what it says that, but Cadbury, we all know that Nestle and Cadbury are rivals. So Cadbury says that it raised an objection to the application, since it could establish a monopoly in the four-finger chocolate products. So basically, there were many companies which produced four-finger chocolate products. So Cadbury raised a concern stating that it could affect the monopoly over a four-finger chocolate products across the world. Even though Nestle was successful with its application, the court rejected it. So this is what happened. So basically, what Nestle says is that Nestle argued in a survey that it conducted a survey, and when people were given with a four-finger marked, a four-line strips of symbol was shown to people, 90% of the people immediately identified the four strips to be Kit Kat's trademark, official mark. So this was submitted by the Nestle's argument, but what happens that the court rejected this particular claim. It said that you cannot have monopoly over it. So, okay, so basically why they rejected is that the court held that the survey has failed to fulfill the definition of trademark under section 1 clause 1 of the Trademarks Act. So basically it doesn't come under it. The court said that the particular four-fingered shape of Kit Kat doesn't come under the definition of section 1 clause 1 of the Trademarks Act. That is, the definition of trademark is given under section 1, and it doesn't fall under it. So this is one explanation given by the court. And the court also raised concerns whether the shape could be single-handedly distinguished. Okay, so the goods as those of Nestle without the use of other visible trademarks such as the Kit Kat logo. So basically the court also said that if you just give away these four bars, there are few people who cannot recognize it, even though if it does not have the Kit Kat logo on it. So this is one among the concerns raised by the court in this particular issue. The shape was prohibited from registration. So in this case, the four-finger shape was prohibited from being registered for a trademark, and later what the court said is that the rectangular shape, that is the rectangular shape of each slab of the Kit Kat, and the grooves dividing the fingers, that is the gap dividing the each rectangular shape bars, and the number of grooves, basically the four bars in it. So the Kit Kat, what it does that, it says that I want to register these particular things alone, that is the rectangular slab and the gaps between, that is the grooves dividing the fingers, the gaps between them, and the number of grooves, that is the four grooves. Yeah, we know, right? So so what the court now says is that as per section 3 of the Trademarks Act, trademark cannot consist of shape that results from a nature of goods. So basically in this case, if you look at it, the four-finger mark is derived out of the arrangement of the wafers on it. So the court said that since the bars are arranged in such a way, the particular shape cannot be claimed as claimed, because it is the nature of the goods itself, and the shape of the goods necessary to obtain the technical result. So basically when you have to obtain a particular result, the shape of the good might vary based on that. So you cannot claim a trademark even on that. So basically the court says is that what the court says that the decision and the decision of the court is that you cannot register this particular Nestle product, because it is the former source of producing the chocolates is in that particular shape, is in the rectangular shape, that is the wafer is in the particular shape, and producing the chocolates is going to give you the same shape. So basically the court says that you cannot register it. So what are the implications of this particular decision is what we are going to see now. Every businessman, the court held that it cannot be considered to be a monopoly in the market, right? So basically what is that the businessmen should be very aware of the implication of section 3 of the Trademarks Act when applying for trademark registration. So every business should be very aware of the section 3, that is, it should have a distinctive feature for it to be considered as a trademark, and also that it shouldn't it shouldn't use that particular source from which the particular product is derived as a trademark. So these are the implications of this particular decision, and these two cases are very, very important with regards to section 3 of the Trademarks Act of 1994. So with this I conclude this video, and if you have any opinions regarding this particular case, or if you would like to know about any other case with regards to this particular section or with regards to trademarks, kindly drop it in the comment box, and the company would make another video for you guys. Thank you so much, and have a good day.